The issue the problem that I have is that when you first got on your probation, we sent you to the cognitive track of ISF so that you could get tools to be able to be successful and do better and make it through probation. And when you got Brown?
Yes.
My tablet's but not letting me do something. Now it is. Well, maybe.
Give it just a second. Slow like my computer works.
It opened the wrong one in the background, that's why. Hold on a minute.
Good morning. Are you Isaiah Brown? Will your client waive the formal reading of the indictment?
It will.
Mr. Hoffpower, this is yours on Isaiah Brown. Okay, so it's a reduction to state jail.
Yes, ma'am.
Okay, Mr. Brown, in cause number 25 DCCR 0356, the state has elected to proceed on the lesser offense of a state jail felony, abandoning or endangering a child with intent to return from February 9th of 2025. And how do you plead to that charge? Speak up. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yeah.
Do you fully understand them? Answer out loud.
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes,
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No, sir.
It's admitted. Is there any evidence that Mr. Brown is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that we can get a pre-sentence report done by probation. Then we'll come back at a later date for sentencing. Mr. Hoffpower, what is the state's position with regard to a bond based on the nature of this plea?
We have no position.
What is the
Just a,
what's the relationship to Kinsley Segura?
that's
Mr. Charles,
a child.
this is,
It's my little brother.
It's your daughter?
No, he's not with the mother. You know,
I'm sorry?
They have custody. I'm not sure if he, what kind of.
Do you
custody.
have any kind of,
No, she blocked me when she had my baby, so I'm not on the birth certificate. I'm not on none of it.
so until anything happens legally with that, you cannot have any contact with your child, you understand?
Yes.
Okay, so what I'm going to do, based on the nature of this plea agreement, between now and sentencing, is reduce your bond in your case to $1,000. If you make that bond, it's very important that the first thing you do is go to the probation department so they can start that pre-sentence report, okay? Also, a condition of that bond is that you have no contact with Kinsley Segura, okay? And then we'll see you back at sentencing. All right, you can go back with the bailiff. I don't know what's wrong with this thing. I don't think it sent it to you. It's not responding again. Now I got an unhandled exception. Because I tried to, I think I didn't send it to you, or it showed up here even after. All right, let's try it. Ms. Holmes, will your client waive the formal reading of the indictment? Mr. Brousard, in cause number 25, DCCR 1442, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from July 27th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
We've got, it's admitted. I know, back up.
Sorry.
Is there any evidence that Mr. Brousard is not competent?
No, Your Honor.
You need one?
Thank you.
All right, Mr. Brousard, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what is the state's position with regard to bond reduction based on the nature of that plea agreement?
Your Honor, he has a prior successfully completed probation for deadly conduct. The situation involves an in-home argument with his adult sister where he shoved her and brandished a machete. My concern would be if he was released, where would he be awaiting sentencing?
Mr. Brousard, when you are released, whether it's on a bond or when you get this probation, where will you be living?
4948 Lawndale.
And who lives there?
My mother.
Who else?
There's 2 other couples. There's Lindsay's daughter, my niece, and her boyfriend, and another couple.
Okay, where does Lindsay live?
Lindsay lives at the lake, Toledo Bend.
So you understand that you're not going to be able to have contact with Lindsay?
Yes, ma'am.
So if there's some family get-together at the house where you're living, you're going to have to leave if she comes
Judge,
over?
I do have that address as her address in my file. I'm not saying she doesn't live at the lake or whatever.
Okay.
And I'll let the court know she called yesterday, spoke with my investigator, wanted to drop charges. But because of the evidence in this case, I think I can prove it regardless. That's why we reached an agreement this morning.
Okay, so what I'm going to do Mr. Broussard, based on the nature of your plea agreement, is reduce your bond pending sentencing to $1,000. If you make that bond, there's some very important conditions. First, the very first thing you do when you're released is go to the probation department so they can get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement. The second thing is that you're to have no contact or communication with Lindsay Gaspard. So if she is living there, you're going to have to find another place to live. You're going to have to figure that out, okay? If I find out that you're having any contact or communication, or she contacts the DA's office and lets them know that, then you run the risk of me not accepting the plea agreement. All right? Okay, you can go back with the bailiff.
Thank you, Your Honor.
Thank you. Jacoby Frazier,
Was it competency?
let me just go through, y'all don't have an agreement, just, yeah, y'all just need some time?
Yeah.
Okay, I'll make that finding and then reset it.
He's competent, so.
Fraser.
Hey, Judge Witz.
Good morning, you're Jacoby Frazier?
Yes, ma'am.
And Mr. Frazier, it was evaluated for competency to stand trial by Dr. Kaplan in cause number 25 DCCR 0732. I've received that report and will take judicial notice of the court's file. Excuse me. That report is dated November 3rd of 2025. The finding is that Mr. Frazier is competent to stand trial.
Yes, ma'am.
And is there any other evidence with regard to competency?
No, Your Honor.
Not from the state judge.
All right, then at this time, I will make the finding that Mr. Frazier is competent to stand trial. And then, Ms. Holmes, do you need some time to get out and visit with him with that? And
I do know that last time we did have a plea agreement. I believe we had done the paperwork, but then there were some issues where he was needing to be examined.
okay, if y'all want to attempt that, I can hold it. If you
Okay.
want to try to go through it today, then we can take all that into consideration and see if we can get there.
Yes, ma'am.
Okay.
Yeah, I'll try to do that.
Okay, I'll hold it to see if we can get it taken care of. And if you need more time, just let me know.
You're gonna talk to me today?
You still have the paperwork? Hold on. Do you want to talk to him for a minute first and then?
Yeah, let me.
Okay,
check
go ahead
real
and
quick.
send it, but y'all visit and I'll hold it for a second.
Okay.
Mr. Lewis, you got Kadesha Eli? That's a sentencing? Bless you. Sneezing, coughing. Happy holidays. All right, you are Kadesha Eli. And Ms. Eli was previously in court, entered pleas of true to a motion to revoke probation on probation for injury to a child, elderly, or disabled individual. Entered pleas of true to counts 1 through 8. I've received an updated report. Has everyone had an opportunity to review that report?
Yeah.
Are there any additions or corrections?
Nothing to finish.
Come from the state, Your Honor, unless Ms. Lopez has anything additional to her updated PSI.
All right, thank you, Ms. Lopez. And there was not an agreement, correct?
Correct.
Mr. Lewis, you may proceed.
Well, Judge, Ms. Eli, like I said, was previously placed on probation out of this court. Early on during her probationary period, it seems she had been doing really well, doing well, or has been able to comply with the terms of probation. During that time, of course, she had started having personal setbacks as far as her living situation, as far as where she would live and things of that nature. I believe at some point she did talk with probation about that, as far as trying to get some help with that. And it seemed to be working out well, even gotten to, I think she was living with your mother, your grandmother. And it seemed to try to get back on track, but at some point that situation didn't work out for her either. And that's when things started to really go downhill fast as far as the not reporting and things of that nature. And it snowballed on her. since she's been in custody, she has been able to secure a more stable living situation, of course, with her brother, that will be available to her if the court decides to reinstate her. Also, employment. She has some employment options that's available to her as well. That I think that was her main problem or issue was stability. And I think since during this time while she was already searching for these options, Judge, but they unfortunately by the time they became available to her, she was in custody. Now, when I talk about the situation with her brother for the living situation, that's also one of the job situations as well. Her brother works with Zumo Sausages, the Zumo company, and she actually worked there for a temporary period of time a while back early on, and that job fell apart, but looks like it'll be open again for her to go back. So that's essentially what it comes down to. She's asking now that she's stable to try to see if she can have the opportunity to get out there and complete the probation like she initially tried to and wanted to.
What's the status of the theft in Orange, the new offense?
For as we know, the situation in Orange, there hasn't been a court date or anything up there. So it's still in limbo,
But
at this point, Judge.
Okay. Ms. Malfino?
Judge, I think it's fortunate that we're not here on a violation that involves a child based on the underlying nature of this probation. But I also think it's unfortunate that she doesn't have any felony offenses, was given this many opportunities, and as this court is well aware, a very good officer to work with in Ms. Lopez, and she has not done what she has been required by this court to do. So I would stand with Ms. Lopez's recommendation and defer to any other comments she might have.
So, Ms. Eli, the problem that I have is that when you first got on your probation, we sent you to the cognitive track of ISF so that you could get tools to be able to be successful and do better and make it through probation. And when you got out of ISF, you were put on the high-medium caseload so that you would have help with all of these issues that Mr. Lewis is talking about, help with places to live and with jobs. And you were given all of that. And so for me to say, okay, you've already been given all that and you didn't take advantage of it to give you some other opportunity and just let you out when I've already given you these sanctions. And the underlying case is just very, very serious. And the fact that you got a probation was a big chance. And if you hadn't already been to ISF, then maybe I'd be thinking about, okay, let's do ISF or let's do something to give you some tools to do better. But we did that and you didn't take advantage of it. So at this time, I'm going to find that you entered your pleas of true to counts 1 through 8 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of the offense of injury to a child. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This is not a plea agreement, and so you do have some rights to appeal. You can talk to Mr. Lewis about that. I'm handing you the trial court certification. It shows you do have that right to appeal. I need your signature on that, and I'll get you a copy of it. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, you can sign that, and y'all can take the bottom 2 copies. Say Leonard Guillory.
Today's courtroom opens quietly, But beneath the routine greetings lies a fragile balance between mercy and consequence. Isaiah Brown stands first, facing a charge involving a child, his future hinging on every whispered answer. What seems like relief quickly turns uncertain as the court prepares to look deeper, setting the stage for what's still to come. As the hearing unfolds, the tension thickens. Another defendant steps forward, another plea is entered, and the judge's patience is tested by violent facts and hard boundaries. Each decision feels temporary, each bond reduction conditional, leaving one question hanging: who will walk out and who will be taken away by the end? By the final cases, the courtroom transforms from procedural calm into emotional reckoning. Judge West presides over lives paused in midfall, weighing opportunity against repeated failure. Isaiah Brown's case begins with cautious hope, deferred probation, a reduced bond, and strict orders to stay away from his child until the law says otherwise. Freedom is offered, but only on fragile terms. That fragile mercy echoes again with Spencer Brousard, who admits to aggravated assault involving a machete during a family argument. The judge listens carefully, granting a bond reduction but drawing unmistakable red lines. No contact, no excuses, no second chances if rules are broken. Then comes Kadia Eli, and the tone shifts. Her history tells a story of chances already spent: probation, treatment, supervision, support. The judge explains those tools were given and ignored. This time, there is no reset, no bond, no delay. A 4-year prison sentence is imposed. In this courtroom, justice is not loud, but it is relentless. Mercy appears briefly, discipline follows closely behind, and every ruling reminds everyone the law remembers what it has already given. Consequences linger long after the gavel falls. No one leaves unchanged forever inside.
This is not just a case. This is a fight for justice, where one question from the judge can change a life forever. The silence of the victim, the arguments of the lawyers, and the verdict that decides the truth. Welcome to Court and Courtroom, where every case reveals a new truth, and every truth leaves a lasting impact.